Hi everyone, I'm Angie Holloway, the lawyer for doctors. In this quick 15-minute or so video, we're going to answer the question, does your HIPAA compliance policy look like this, right? So this is a 3-second test to see if you are HIPAA compliant. All right, so what are we going to talk about today? First, the most common HIPAA mistake that I see that Georgia small practices make. Number 2, what HIPAA actually requires. And number 3, how to avoid a catastrophe by failing to protect client patient data. All right, for those of you who have not yet had an opportunity to meet me, I am Angie Holloway and I am the lawyer for doctors. We help Georgia medical practices protect their licenses, their practice, and their peace with concierge legal expertise. We help you to focus on exceptional patient care, and we take care of all the legal. I've been practicing law for about 8 years now, and I've represented individuals and businesses in state and federal courts all over Georgia. A couple years ago, I transitioned my practice to transactions, and so now I focus exclusively on helping my clients avoid court. Okay, so let's go ahead and get into it. And the 3-second test is this. Does your HIPAA compliance protocol look like what's on this screen? All right, so a lot of you may have this. You probably downloaded it from a federal government site or maybe your prior employer. And this is a HIPAA Notice of Privacy Practices, or an NPP. A lot of times I see small practices, they have this, right? They have this form, this standard template. They let their patients fill it out, but that is it. That is the extent of their HIPAA compliance protocols. And that is the number one mistake that I see. You're taking a too long, didn't read approach to HIPAA. Downloading an NPP and having your patient sign it is not sufficient to comply with HIPAA requirements. All right, so let's get into it. What is HIPAA and what does it require, right? So the Health Insurance Portability and Accountability Act, HIPAA for short, has 3 primary components. The first one is the privacy rule, the second one is the security rule, and the last one is the breach notification rule. Now, this is intended to be kind of a one-on-one. This does not cover every nuance or exception that applies under HIPAA, but it's just to give you an understanding of what the overall umbrella is and what is required. All right, so the privacy rule one-on-one. So this rule basically provides protection for protected health information, or PHI. It applies to covered entities and business associates. A covered entity, for the purposes of this video, we will assume that these are medical practice providers in Georgia. So physicians and individuals like physicians who are providing services. A business associate is a third party that may be providing some business level services to the covered entity. So for example, someone who's doing medical coding or medical billing is an example of a BA if you have delegated that to a third party. So that third party is going to be needing access to PHI in order to do their job. And so you would have that person or that entity or individual signed that business associate agreement in order to basically govern the relationship between the CE and the BA, right? And so normally what you would see in that agreement are the terms for indemnification, for example, how you guys are going to handle a breach, what's going to happen if there's a suspected breach, and things of that nature. There's a template that you can find on the HHS website, but it's not as well drafted as it should be, but it's a good starting point. All right, so privacy rule also covers the NPP, right? So we've kind of already gone over that, the notice of privacy practices, and that's kind of the bare minimum. And the privacy rule also talks about when consent is required versus when it's not required, right? So in order to submit billing, for example, to a health insurance plan, you are not required to get additional consent for that, right? That's something that's required and it's expected during the course of providing medical treatment. However, if you are going to use any type of PHI or protected health information for marketing or sales or some other non-anticipated use, you are required to provide consent and get consent from your patient. All right, the security rule. The security rule basically governs a patient's right to inspect and copy their health information, their health data. Normally, that needs to be provided within 30 days, and your health policy protocols for HIPAA should govern and provide information to your patients about how they can go about requesting that information from your organization. It also allows patients to request an amendment to their health record within 60 days. There are some parameters around that as well, but normally that is what is allowed under the security rule. And lastly, there are like self-pay restrictions. So for example, if a patient is going to be paying out of pocket and they're not going to be submitting that information or that claim through their insurance, they can require or request that you restrict access to that information from their health insurance plan, for example. All right, the breach notification rule. So this is a pretty good definition, and so I'll just read it and we'll talk about a little bit. So a breach is generally an impermissible use or disclosure under the privacy rule that compromises the security or the privacy of protected health information. An impermissible use or disclosure of unsecured PHI is presumed to be a breach unless the CE or the BA, the covered entity or the business associate, demonstrates, based on a risk assessment, that there is a low probability that the PHI has been compromised. The important part about this is that you have to conduct a risk assessment first. And second, there's a presumption that there's a breach, right? Until you have determined otherwise based upon the risk assessment. So let's talk a little bit about what a risk assessment protocol is. So it's basically a four-part assessment where if there's a suspected breach or misuse of protected health information, you're trying to figure out who, what, when, where, why, and how, right? And so the first aspect is for you to determine what the nature and extent of the use or disclosure is, right? So you're trying to figure out what type of identifiers were actually disclosed. So something to think about would be, is it birth dates? Is it actual like patient visit data? Is it social security numbers? What is the extent of what was actually disclosed? Number two, you're going to think about the unauthorized persons or agencies who had access to the protected health information. So something to think about, maybe, for example, you disclose information to a sibling. Instead of getting a consent from the patient, you just went ahead and disclosed it prematurely, right? That can be an example of unauthorized access to PHI. Number three, you're going to determine what the likelihood that the PHI was viewed or acquired. And so what you would need to do in this instance is to conduct kind of an audit analysis, right? So you need to figure out what data was accessed, and then the likelihood that it's actually been viewed, right? So have we gotten to the point where we're past encryption, right? Was there an attempted access or was it actually viewed? And lastly, you're going to look at mitigation efforts. So from the suspected breach or the breach of the data, what has happened since then in order to minimize the impact to the patient healthcare data being exposed, right? So for example, if this is a situation where an employee has posted someone's PHI on Instagram or online or some type of social media platform, has the employee's access been revoked? So that's the first thing that you would want to do and make sure, or maybe you need to change the encryption key. Depending upon the type of breach, would influence what type of mitigation efforts are necessary in order for you to move forward with your risk assessment. All right, so HIPAA actually has a 7-part protocol that you have to follow in order to be compliant. It's not just an NPP. And so these are the 7 different aspects of HIPAA that you have to comply with in order to protect PHI. So the first one is policies and procedures. And so again, it's not just a notice of privacy policies. It's an actual structure of what you're going to do as an organization in order to protect patient data. If a breach happens, how you're going to respond to it, and a number of different other protocols that need to be within that in order to make sure there's a system of compliance versus just having something that's on paper. Number 2 is compliance leadership. So you are required to identify a privacy officer. This is an individual who is going to be responsible typically for beginning the risk assessment process. They're the person where you can make complaints or reports to, and they're going to be the person that's going to be spearheading compliance for the organization or private practice. Number 3 is training and education. And so a lot of times you'll think that, okay, when the person is newly hired, you'll go over what is required under HIPAA, and then that will be kind of a set it and forget it. That is not what HIPAA requires. HIPAA requires ongoing training and education. So laws change, things are updated, maybe you've changed your EHR. There needs to be regular intervals where employees are getting new information, new policies, new procedures. At the very least, that would be once a year. If you're a smaller organization or there's high turnover, you might want to evaluate whether you would need a quarterly or a semi-annual type of regime, in order to protect your healthcare organization. Number 4 is effective communication. So this is basically the procedure by which you're going to go through and communicate what's happening with the private practice, right? So if there's a suspected breach, who needs to be notified first? How do you notify patients? What is going to be your breach protocol mechanism by which, if you need to notify, for example, HHS or the media, depending upon how many people PHI has been exposed. Number 5 is enforcing standards. So most companies have a kind of a blanket policy that says, in the event that you breach our protocols, you may be subject to up and to including termination, right? So the enforcing standards should be some type of tiered process by which you say, okay, if there's an inadvertent disclosure, this is how we're going to handle it, right? Maybe there's a certain number of hours of retraining that you're going to provide to the employee versus if there's a deliberate one, maybe you say, hey, we're going to terminate that person, or maybe you're going to put them on a performance improvement plan. There needs to be some kind of unbiased mechanism by which you can evaluate when people are not complying with HIPAA and specific consequences for lack of compliance. Number 6, auditing and monitoring. And so this is one of the technical safeguards that needs to be in place for HIPAA compliance. Normally, your EHR is going to have this on the back end, sometimes on the front end, where you can pull reports to see what is happening with respect to employee access. So if someone's going in and deleting, for example, patient data, right, that doesn't comply with HIPAA, right? So making sure that you can see who's doing what, right, and monitoring their two-factor authentication, for example, encryption, all of those types of things. And then the monitoring is how often are you reviewing that data, right? Are you looking at that once a week, once a month, once a quarter? Depending upon the size of your organization, you're going to have regular intervals where you are looking to see whether or not the systems that you have in place are effective. And so that monitoring compliance program requires you to look at that not just once a year, right? And lastly, you have a response and development interventions. And so what this protocol is designed to do is to provide some form of incident plan, right? So in the event of a breach or a suspected breach, this is how we're going to respond. This is how we're going to mitigate any type of, additional exposure for patient data. This is how we are going to communicate with the privacy officer or the privacy committee if it's a larger organization, depending on what you need, right? So we have a specific system in place of how we are going to respond in the event of an incident, whether that's a breach or a violation. All right, so what happens if you violate HIPAA? So the HIPAA enforcement rubric is a 4-tier system, right? So tier 1 being kind of the least culpable, and tier 4 being the most, right? So tier 1 would be if you didn't know and you couldn't have known, even if you exercised reasonable diligence. Tier 4 is a willful neglect, meaning a knowing violation that you don't correct within 30 days. So the span of the actual fines for HIPAA violations is large. There's a large disparity. So you can have something as small as, a couple $100s for a tier 1 violation, and it can go all the way up to $1.5 million for a tier 4. And then you have, the different numbers in between. Obviously, repeat violators, you kind of increase the amount of the fine. The primary purpose is just to understand that you are required to exercise reasonable diligence. It is not enough to say, hey, I hope that, my patient data isn't compromised. There has to be some type of compliance program in place beyond an NPP, right? That's ultimately what I want you to gather from this specific thing. And obviously you want to be able to avoid these huge penalties and fines. All right, so on here, just very briefly, you can see some of the data up through October of 2024, and they kind of show you what the top issues are for HIPAA in compliance, and also showing you who's kind of the top violators, including private practices and physicians. All right, so hopefully this isn't too much information. Again, this is kind of a HIPAA 101, just to give you a good foundation to understand what is required for you as a Georgia private practice owner. If you're feeling like this is so much, I'm overwhelmed, all I have is an NPP, you feel called out, don't worry. What I would recommend is for you to book a discovery call. That's a 30-minute call. We'll talk about what kind of protocols you have in place, any specific questions that you may have about the different protocols that are required under HIPAA, and how to get you compliant and to create a culture of compliance where you're not just, having some kind of paper HIPAA policy that is not actually a practice within your organization. Again, thank you so much for watching. I am Angie Holloway, the lawyer for doctors. If you're ready to audit your HIPAA compliance protocols, book a discovery call for our specific recommendations. Talk soon. Bye-bye.